Every success has its own story. And in case of PCCOER, short for Pimpri-Chinchwad College of Engineering and Research, the story began from its very inception in the year 2014. We are creating this success story under the aegis of Pimpri-Chinchwad Education Trust, PCET, which was established by late Shri S.B. Patil in the year 1990. The trust has the vision to provide value-added education to the society in multiple dimensions, right from nursery up to doctoral program in all professional streams. PCET is a well-established and time-tested brand in education. PCET governs 9 institutes, which include a public school, a polytechnic, a management institute, an architecture college, a science and commerce college, and 4 engineering colleges.
Pimpri-Chinchwad College of Engineering and Research is one of the leading colleges of Pune University. We follow the simple principle of 5-pillar philosophy. In this 5-pillar philosophy, the academic excellence is the first and the important pillar. The second one is research and innovation. Third is the training and development aspect. Fourth is the social awareness angle, and fifth is ethics and values. As a result of this, the students are developed in all dimensions, and the college is emerging very fast among the top colleges of Pune University as well as at the state level.
PCCOER has been founded by highly qualified and proficient academicians. We are located in the most refined cluster of innovative firms at the heart of an industrial hub. Here, our students have numerous career opportunities. PCCOER runs UG courses for civil engineering, computer engineering, electronics and communication engineering, and mechanical engineering. These courses have been approved by AICTE, DT, and Government of Maharashtra. The institute is affiliated to Savitribai Phule, Pune University. PCCOER is a place of excellence where your vision comes true. At PCCOER, you can wander through the ocean of knowledge and build the courage to seize your aspirations. We merge technology and participative learning to make your education more engaging, more gratifying. PCCOER has a skilled team of experience.
And I'm very happy that you are associated with us for our second conference as well.
Sure.
Okay, sir, we are starting.
Sure.
Okay, dear viewers, a hearty good morning and a warm welcome to the second day of CIPSIS 2020, that is Conference on IPR, Patents, Copyrights, Innovations and Startups. And today we have with us 3 keynote speakers, beginning with Mr. Ram Sitaraman from Mahindra Rise. And it's a pleasure and privilege that I'm being given the honor of giving introduction of Mr. Ram Sitaramji. Mr. Ram Sitaraman is currently the IP head for Mahindra and Mahindra for both the automotive and farm sector. He takes care of overall knowledge management and standardization initiatives in manufacturing as well. He has nearly 20 years of industry experience and with varied organizations like Mahindra, General Electric, Infosys, Wipro, and Tata Unisys while working across different business verticals. He has a master's degree in science from State University of New York, that is SUNY, at Binghamton, specializing in advanced electronics packaging. His areas of interest and passion lie in the field of IP analytics and business intelligence for driving strategy and innovations. He is also certified level 2 TRIZ innovator. Apart from this, he has also driven functions of IP creation, drafting and prosecution, IP in M&A and commercialization at different organizations. I am extremely pleased and honored to welcome Mr. Ram Sitaraman, and I'm also happy to announce that he has been, or rather he is gracing our conference as a keynote speaker for the second time. So a very warm welcome, dear Ram Sitaraman sir, and I express my gratitude and I request you that you may kindly start with your keynote speech.
Sure.
Thank you very much, sir.
Thanks, Dr. Samir, and thanks to the entire SIPSIS organization. I'm very happy to be here, and I'm honored to be here and present the second time in a row the keynote speech. So last time I had talked about how IP can help in the business. So this year I wanted to take a step back and go back to the fundamentals and basics or foundations of our intellectual property, and how as an inventor can I strengthen and protect my own invention. Last time when I had actually spoken to a bunch of the people in the audience, and there are a lot of students. So one of the key areas that popped up was like, we have great ideas, but we want to know how to make it strong enough that it has the highest probability of succeeding when you want to protect it. So with that thought in mind, I thought I'll have a very brief session. For some people, this might be very fundamental and basic, but I hope that this shares a few tips and tricks in how to look at your own idea from a way where we can strengthen it to a point where it gives it the highest probability to succeed. So with that, let me start my my talk for today. The topic is, as everybody can see, what is intellectual property, how to strengthen and protect your invention. So let me start off with the basics. So what is intellectual property? If you look at the standard definition that WIPO talks about it, intellectual property refers to creations of the mind such as inventions, literary and artistic works, designs, symbols, names and images used in commerce. Now, broadly, it covers various types of intellectual property, and we'll come to that very shortly. But it covers aspects of inventions, creative work, designs, logos, symbols, names, and images. Now, the key word out here that I want to point out to you or point your attention is creations of the mind. Like physical property exists, intellectual property is usually referred to the creation of the mind. Now, you can see some of the examples out there that you can see vehicles, books, music, all of these fall under different types or different categories of intellectual property. Now, I have a slide, next slide following saying intellectual property rights. A lot of times people think intellectual property rights are identical or similar. In a broad sense, probably yes. But the way I look at it is, if I take an analogy from the physical world, I have a property like a house. Now, the legal rights to that house is separate, what is given to me as the owner of the house. So from that way, if I have to drop an analogy or a comparison, I have an intellectual property. There are legal rights accorded by the national government to that property. Those are what is called intellectual property rights or IPR. Intellectual property rights or IPR refers to the legal rights provided by a national government to an inventor or assignee to help them in protecting their inventions and enjoying its full commercial benefits for a finite period of time. Now, there are two phrases that I've underlined in red, which is what I want to draw your attention to. One is provided by a national government. And the reason I put that is intellectual property is geographically constrained. And what we mean by this is it is very territorial by nature. If I file for a patent in India, it is enforceable and valid and protectable in India. You cannot go and protect its rights in US. And similarly, if you file for a patent in Europe or US, it's only valid in that country and is protected by that law and under that government rights, not in any other geography. So that's what we mean by saying intellectual property is typically territorially constrained or territorially driven. The second part that we have is finite period of time. with a very few exceptions. And I'll briefly touch upon it a little later. Most of intellectual property rights are only for a finite period of time. What we mean by this is the lifetime of an intellectual property that you've created and protected to enjoy its full commercial benefits is usually for a finite period of time. If I take the example of patents, it's 20 years from the time of filing. So similarly, copyrights, trademarks, all of them have finite period. Some intellectual property types do have a capability where you can extend them, and you can keep extending them probably n number of time without any break, as long as you satisfy some thresholds. Which is why I said that some types or some categories might push the envelope when it comes to finite period of time. But in essence, in generality, intellectual property rights are usually for a finite period of time for most of the types. For example, trade secret, as long as it doesn't get pulled into the open, or it's not opened up by anybody else, and as long as you can maintain it a secret, you can actually keep it for an indefinite period of time. So let's look at the rights and value that an intellectual property provides to somebody, to an inventor or the owner. Rights are almost exactly the same as any other physical property. This is a great example that I typically give. When you want to understand the rights from a legal point of view, think of any physical property. House is a good example. When you own a house, there are certain rights as an owner that comes to you. You know the exact location of your house. It's given by on your, say, your registration certificate or your sale deed. It's given where exactly is your house, the dimensions of the plot or the land on which the house resides. Then it will say that you have certain rights that come with it, which essentially means that you can make money out of it by selling it further downstream, or you can rent it out, license, and so on and so forth. Those are exactly similar to how you treat an intellectual property. Treat intellectual property very similar to any other physical property, and the rights are pretty much similar. Can be sold, licensed, leased, or rented out, can be used as collateral to secure loans or lending at banks, can be transferred to your descendants as well as part of your will and estate. So pretty much it mirrors how a physical property is treated by national governments under law. Now we come to a fundamental scenario of what are the types of intellectual property, and I hinted about this in a couple of slides back. There are other types of intellectual property, but broadly, I would like to focus on these 5, which is something that most of us would encounter on a daily day-to-day life. You have patents that most of you are aware of. You have copyrights. You have industrial designs. You have trademarks, and then you have trade secret. If I have to look at a very simple one-line definition of each one of them, if I look at patents, they are typically technical or functional solution to a problem that you're trying to solve. So the technical functional solution approach to a problem can be protected usually under a patent. When I look at copyright, copyright is more like an expression of an idea which is represented in a tangible medium. So you have an idea inside your mind is typically abstract form. But the minute you express it into a physical tangible medium, like say paper or a canvas or even a photo, then that expression of an idea in that medium is considered copyright protectable. Trademark, symbols, logos, images that convey the value of the product or service of a particular organization or a person or a company. So you have seen so many logos across your, I've shown Android logo out here. If you see the logo of Apple, or if you see the logo of BMW on a product, there is a certain value that you associate with that particular product. There is a trust, there is a credibility, there is a value attached to it. That is the power of a trademark. Symbols, logos, or images that convey value of a product or a service to an end consumer. Trade secret, process or material that is held secret to get competitive advantage. As the name says, it's typically kept secret within the organization, but it gives a benefit to the product or a methodology that you're using, which you don't want your competitors to find out. Therefore, instead of pushing it under patents or designs, I keep it as a secret. And why I called out patents and designs is, at the end of the day, when you file for a patent or when you file for a design, you are getting protection under patents and designs, but you're also putting it for public record or public disclosure. People know exactly what the patent is about, which is required so that they don't actually infringe or misuse your property. And they also know how to improve or develop further on it. So with all of the patents and designs and these scenarios, you end up disclosing your idea and invention and getting protection for it. But if you don't want to disclose it and you want to keep it a secret, to ensure that you have an advantage over your competitors, trade secret could be a potential way to go. Some examples of trade secret could be like your client listing, or your way in which you might have a unique mathematical approach to, or a way to, a methodology to get a pricing proposal for various clients and lists and so on and so forth. Ways in which you want to actually performance manage your entire organization, which might be unique and very secretive to the way you want to handle it. These are things, as I said, process or material, you want to hold secret to get a competitive advantage. Some well-known trade secrets in the world are the mysterious 7x ingredient inside Coca-Cola that is supposedly making it one of the very unique, distinctive colas apart from the other cola brands. And then, of course, you have the KFC's trade secret spices that gives it the crispy fried chicken, the flavor that you know. So these are some examples of trade secrets that you might have heard of in the commercial world. The last one, the type of intellectual property that I'm looking at out here, is industrial design. So while a patent talks about technical and a functional solution to a problem, an industrial design is focused only with the aesthetic, shape, or form factor. So it's only to do with the shape or the form factor, and it's got nothing to do with the functionality of the system. So this is the difference prima facie between patents and industrial design. So for the industrial design example, what you can see in the screen out here is the shape of the Coca-Cola bottle, which was so unique, which was actually protected under industrial design. Now, we talked about intellectual property, we talked about types of intellectual property, and we talked about the rights associated with it. Now, a lot of you would be asking, why is IP so critical that organizations, academia, all of these people are talking about it, and we hear about it in media from time to time? There are benefits and there are, of course, risks. So what are the benefits of actually following or adhering to intellectual property? You get branding and credibility, premium pricing, differentiation from competitors, and entry barrier in markets for new players. Let me break this down. The first three are pretty much connected to each other. Branding and credibility, as I said, you see a product with the logo of BMW, you see the product with the logo of Apple. There's a certain branding, there's a certain credibility, there's a certain value, there's a certain quality of product that you expect. That is the power of a trademark, that is the power of intellectual property. And look at it from innovation and patents also. Google is considered one of the most innovative companies, so is Tesla. And they have a huge patent portfolio to actually showcase the fact that they are very innovative. So is IBM, and so is Intel. So there is a particular branding and credibility that goes with the fact that you build IP, it is linked to innovation and linked to the fact that you are coming up with unique advances, which your company is known for. Premium pricing. From the way an intellectual property works, it's very simple. You own an intellectual property, nobody else can use it unless they take license from you or take permissions from you. So then what you're able to do is, I can say that I can prevent people from utilizing something which I could potentially offer myself, and thereby give a premium pricing to my products. This also enables you to technically differentiate what feature you provide versus what features others cannot provide, to a differentiation against competitors. That is why I said these three parts will actually get interconnected with each other to provide a benefit of IP. The last one, that is entry barrier in markets for new players, is a way of looking at it in terms of offensive way of utilizing IP. Suppose I get into a new area, a new geography, like say Africa, and I have fundamental patents in banking environment out there. So a new player who wants to come into Africa and wants to commercialize and sell a product, and if they're actually their product features impinge upon some of the fundamental patents in banking that I got out there, they cannot put the product out there without infringing my patent. So their only recourse would be to reach out to me for licensing, or to look at other ways in which I could be recompensed for utilizing my patent to bring a product out there. So it tends to become an indirect entry barrier in markets for new players. So these are some of the benefits that you can utilize while manipulating or exploiting IP to your benefit. The risks are, of course, there. You're talking about litigation, lawsuits, loss of time and money. What it means is, it goes back to the fundamental edict of intellectual property. You cannot use someone else's property without taking permissions from them. Using of someone else's intellectual property is considered infringement, and typically it gives the owner of the intellectual property all right to initiate a litigation or a lawsuit against you. And this would have damages, it will have loss of brand credibility and value, and there should be a loss of time and money to the organization that is defending the lawsuit. And if in case it loses, there's a lot of issues in terms of business continuity revenue that will also kick in. So think about all the famous cases that you could think of, and the people who lost it have been, there's a branding and credibility loss. You know that those people have been essentially accused of copying or utilizing someone else's IP without any respect or taking permissions for that. Then there is a stoppage of products like injunctions. So business continuity gets hit, revenue gets hit, and at the end of the day, any lawsuit does not get over very quickly. In most countries, it takes time, effort, and a lot of money, and there's no guarantee that the end result is in your favor. So all of these put together pose a significant business and a financial risk to an organization if they do not look at, be aware of the IP risks and actually mitigate it accordingly. This is a very important slide, even though it's very simple, and I just put it to give an idea of the numbers that we're talking about, but this gives you an insight into how IP is being utilized across the world. Monetary importance of IP. This is an old article. It came out in 2018. But you can see the point that I'm trying to make out here, that Qualcomm made around a quarterly revenue of $1 billion on just on IP licensing. What it means is you've created a product, it's a one-time effort, but that product is your own IP. So you can keep licensing it to multiple clients. The same product which required one-time effort, one-time money investment, you created a product which is your IP, but you can license it a number of times to different clients and get different revenue streams of money. So Qualcomm is making a quarterly revenue of $1 billion US just on IP licensing, means that without creating anything new for that year, just on licensing revenues of IP that they have created earlier, they get $1 billion revenue. That's the power of IP done right. Now, let's look at the flip side. Most of you would be aware of one of the greatest cases that we have had in IP. It's a watershed case, Kodak infringement of Polaroid patents. It started in, I think, mid-70s. The judgment came out in 1991. It was not a huge number or anything. Finally, the court actually identified that Kodak infringed 7 of Polaroid's patents. But the number, the damage that they gave was that Kodak had to pay Polaroid close to $925 million US, that is with interest. I think it was $905 million US plus interest. It came to 925. This is in 1991. You're talking about $925 million US. Most of the IP cases damages given has not crossed this yet. And similarly for trademark, you can see the other example that I gave. Coach was awarded $257 million US against counterfeiters. It's a trademark infringement. So the numbers are not small. Some of the organizations, when they see these kind of numbers, it can push them into financial bankruptcy. So the importance of IP, especially from finance and from business, is significant. So this is the reason why IP is so critical, and it's very important that we follow it. It can have extreme high critical impact on revenue, both negative as well as positive. So with that background of intellectual property, let's focus a bit on patents, because the second part of my presentation would be more towards how do we strengthen our ideas and inventions so that I can protect it through patents. So if I look at patents, the definition again from WIPO is like a patent is an exclusive right granted for an invention, which is a product or a process that provides in general a new way of doing something or offers a new technical solution to a problem. So very broadly put, patent rights are exclusive rights granted for an invention, as I mentioned earlier, by a national government, which is broadly falling into a couple of categories. It's either a product or a process or a methodology, which it provides in general a new way of doing something or offers a new technical solution to a problem. So going back to the IP types that I talked about a few slides back, I said it's a technical or functional solution to a problem. That's exactly what they're talking about out here. And some key points about patents is its lifetime is finite. That is 20 years from the time of filing. It requires public disclosure of invention. What it means is when you submit a patent application to the patent office and you get a patent granted, it will be recorded and it will be kept in public disclosure by the patent office that anybody else can search for, understand, and also work on to improve on going forward. Post the lifetime of the patent, it is made free to public for unrestricted usage. What it means is after the 20 years of filing, the patent is considered to be expired and anybody can use the contents of the patent without having the need to pay license fees or permissions from the original owner. Within the 20 years when the patent is live, the only way to use the contents of the patent is to take permissions from the owner, either through license or other means. But post the lifetime, it's made free to public for unrestricted usage. inventors or the owners of the patent can get its benefit fully during lifetime. Patent rights are negative rights. This is something that a lot of people talk about, but the simplest way I want to put it or emphasize it for most of us is that unlike a positive right that allows you to do something, negative rights, the way I look at it, is something that helps you prevent something from being done. If you get a patent granted, what it gives you a right is to prevent somebody else from using what's in your patent. That is what we mean by saying patent rights are negative rights. And the fundamental byline of that I ask for any IP, and it's not just for patent, which is true, is usage of other patents or other people's patents or any other IP without permission is considered infringement, and it can be legally sorted by the owner through a lawsuit or a litigation. So we go to the next statement, which is very obvious. A lot of inventors ask us, is my idea patentable? Now, before we get into the aspect of what makes it patentable, it will be good to know there are certain characteristics or certain areas that are considered not patentable by law. Now, between geographies, say Europe or US and India and other places, there can be small variation, but broadly, some areas are considered absolutely not patentable. So things that occur in nature or naturally, they fall into discovery, and therefore they are not a patentable invention. They are not an invention. Mathematical formulae, computer programs and algorithms, abstract concepts, business methods, mental acts or games, ideas that are frivolous by nature or dangerous to mankind and human life. These are broadly some areas that are considered non-patentable by law. So if your idea falls in any one of these, you will struggle to get it patented because the patent office of that particular geography will more often than not strike it down by saying this is non-patentable subject matter. Now we move to the next statement, which is essentially criteria for patentability. What makes your idea more probable for patenting? So there is something called a none criteria, which is how I was taught so long back by some of the lawyers that I've worked with. So the none criteria essentially is about 3 parameters that are essential for criteria for patentability: novelty, utility, and non-obvious. So novelty means that your idea has to be new or novel against what is considered state of art or what already exists and what is available already in public domain. Your idea should not be accessible or already present in public domain. That's the assumption of novelty. Utility, which is probably the easiest of the 3 parameters to meet the threshold, is about your idea should have a utility or a usefulness value. The third one, which is probably the most ambiguous and subjective criteria, is non-obvious. It's also called the inventive step in India. So this is a little tricky because what it means is when the crux of your idea or the difference between your idea and what already exists is obvious to someone having ordinary skill in the art. Now, these are very, very open-ended statements because they don't have qualification to say who exactly qualifies to be ordinary skill in the art, or what exactly is considered a valid or acceptable difference between your idea and prior art. So, which is what makes this criteria probably one of the most ambiguous and subjective. But at the end of the day, you have to realize quite a few of the patent applications get probably rejected on the non-obvious criteria rather than on the other 2. I've broken it down into, there is an example that I have put below, which is very broadly, but I've broken down non-obvious into 2 categories that I usually classify into, which will help you understand how your idea is potentially obvious, or it's obvious to somebody who has ordinary skill in the art or who knows something about that field. So if you look at the image below as an example, there is a flashlight, there is a hat. Now, if I'm working in a mine, you've seen the miner's hat with the light on it. So broadly put, one aspect of obviousness is that if there is something that does A and there is another thing that does B, you put them together into one single body and it still does only A plus B. There is nothing new it's doing. You just combine them into one body and it's still doing A plus B with nothing new or different. Then it might be considered obvious to somebody who has ordinary skill in the art or who is familiar with that field. It's obvious to put them together and it's not doing anything new or different. So that is one aspect of how people will look at obviousness. The second aspect is something called equivalency. So there I would say that most of us would have played with pencils with erasers on top of them. So if I have to call it out as a patentable invention, I would say it's a writing instrument which is attached or conjoined to a erasing instrument, which is a pencil with a eraser on top of it. So this is very valuable. Now let's say my idea is about a pen with an eraser on top. Now, if I look at the three criteria out here, is it novel? Maybe. I haven't seen a pen with a eraser on top, so potentially it might be new. Does it have utility value? Of course. If I write with an ink pen and I have an ability of a eraser to immediately erase it, it's great. It's got good utility value. So 2 out of 3 is done. What is it? Is it non-obvious? So here is where I would apply the second criteria, which is called equivalency. Now, a pencil with an eraser on top is essentially a writing instrument conjoined or attached to a erasing instrument. That's how I describe it. Now, pen attached to an eraser is also a writing instrument conjoined to a erasing instrument. So there is an equivalency that people will say that for people who are familiar or somebody who has an ordinary skill in art or familiar with that field, pen is an equivalent of a pencil, as in that both are writing instruments. So when you have an already known invention and you're replacing one component or one aspect of it with an equivalency that it already has, then that can also be considered obvious. A great example would be chemical reactions. Suppose I have a chemical reaction which uses a particular gas like halogen gases. Now, the example might be with fluorine, but I could potentially replace it with chlorine because all of them fall in the same category of halogen gases, and they might probably have the same impact also. So those are considered the second criteria, that is equivalency. So whether it is combining something that does A and B put together in a single body which has only be A and B, that is one aspect. The other thing is the equivalency. These two kind of define what is obviousness or inventive step, which is where the third criteria for patentability comes in. It is subjective, it is ambiguous, but keep in mind that this is what the examiner is talking about when they say your idea lacks inventive step or it is obvious. Now, you can tell me that from the below example, and I'll conclude it with this part, this example, the flashlight looks very different, the helmet looks very different. When I put it on the helmet, it is completely different. You're right. That is where the criticality or the innovative aspect comes in. I'm not able to, my invention might not be on the fact that there is a lighting source with a hat to protect your head and a lighting source to light your way. My invention might be how to integrate a light bulb into a hat itself. And that integration would require miniaturization and electronics. Therefore, now the novelty or the crux of your invention has changed. That could be potentially patentable. So this is how I would ask you to start digging deeper into what is the true crux of your invention. It is no longer something that does A, something that does B, I put it into one body. It is not very easy to put it into one body. I have to make technological advancement to integrate it. The technological advancements in that integration or manufacturing or build-up is what I will consider as my patentable subject matter. My patentable invention is no longer just a hat with a flashlight. So that is the evolving aspect of patentability that as an inventor we need to be very, very aware of. So we'll come to the second part, and a quick check of the time. I think we are at around 10. So I roughly have around another 20 minutes and I should get through this very quickly. So the second part of my presentation is how to strengthen and protect my invention. So keeping aside utility, which is assuming that most of our ideas have some usefulness to it, I will talk about how to strengthen against novelty and obviousness. The two questions that any inventor has to answer is my idea or invention new, or is it already known? Or is my idea and invention obvious to somebody familiar with this field? If you can answer this question with the answer, with clearly differentiating what already exists, then you're already on the way to give a highest probability for your idea to succeed in terms of patentability. Let's look at this word that I threw a couple of slides back when I said state of art and prior art. Prior art or state of art or background art in most systems of patent law is constituted by all information that has been made available to the public in any form before a given date that might be relevant to a patent's claim of originality. Now, there's a lot of legal definitions with regards to patents and patent law, but prior art typically, or state of the art or background art, is essentially referring to information that is already in public domain that is existent as of date before your idea even came into the public domain, which is similar or relevant to your own invention. Broadly put, this is how I would ask an inventor to look at it. Your idea is about, say, electric tractors. All the data or all the information that is available in public domain about electric tractors so far would constitute prior art or state of the art as of that moment. So the key factor is you need to differentiate your idea against what already exists to ensure that you get a strong case for patentability. That is where prior art becomes very, very crucial. Whatever is known so far in the field of idea and innovation, called state of art or prior art, has to be in public domain and accessible, and your idea has to be novel compared to over and above what already exists, that is a prior art. So how do we do this? The simple answer for any inventor is, I have an idea. So how do I make sure that I have the greatest success for making my idea patentable? Is that first, let me search what is a prior art. If I know what the prior art exists, I can choose the relevant prior art and then make sure that I can identify my idea or improve my idea or strengthen my idea and differentiate my idea against what already exists. That way, you can say directly, the key aspect of my idea is no longer something that is in public domain. Therefore, it meets two of the critical criteria, that is, it's novel as well as it is non-obvious. It is over and above what already exists. It's not very obvious, or it's not a simple non-inferentive step. There is something that has to be done to come from what already exists, that is prior art, to your idea. So this is the one step process that I would use, which will actually strengthen your own invention. So the 3 steps that I have out here is, know your invention. What I mean by this, know the crux of your invention, know the critical aspect of your invention, so that, like I gave the example, right? Your invention might not be just a hat with a bulb on it, but your invention might be how to miniaturize the electronic component and embed them into the hat so that it works automatically. So know the crux of your invention so that your search for prior art is perfect and relevant, and then you can differentiate again what is actually relevant to your idea to ensure that you have the greatest probability for success. The second step is, of course, search for the relevant prior art. And then once you find the relevant prior art, differentiate between the prior art that exists in public domain so far and your invention. That way you can very clearly say, these aspects, ABC aspects of my idea is something that doesn't even exist in the prior art as of now. That is the problem that I'm solving. That is what is novel and non-obvious about my idea and invention. So step 1, how to identify the crux or the criticality of your invention. Very simple. I follow something called a problem solution system. So it's about writing down on a sheet of paper. So this is something that most of us can do. Clearly write out the problem being solved. Of course, all your ideas, all your inventions is about solving some business problem. Write out what problem are you trying to solve. Then list out the critical components or the key sub-elements of your invention. Your invention could be, say, a lawnmower, but the lawnmower has critical aspects to it: the blade, the power source, the compactness, the mobility aspect of it. So there are various sub-elements and components to your invention. Write it down. The reason you write it down is so you'll know what and all makes up your entire invention, and your novelty could be in the entire invention or it could be in one of these key parts. So that is how it will help you identify where to focus on. What is a technical approach for your solution? So you wrote down the problem that is being solved. What is the technical approach of how you're solving a solution? This goes back to identifying the technical or functional solution to my problem. So if I take the lawnmower example, my technical approach to the solution would be like, probably the problem is blades are getting rusted or blades are getting worn out very fast. So then I would talk about probably a coating, a special coating on the blades, which will actually keep the blade sharp and also reduce the wear down. So this could be then my technical approach to the solution. My idea now is going to be essentially a coating to improve wear resistance of a blade and to improve the life of a blade. And my solution technical approach is actually a chemical composition. So that is what I mean by saying technical approach to your solution. Then write down this entire thing as a problem solution system. What is the problem that I'm trying to address? What is the solution that I've come up with? And what are the components and subcomponents that make up my solution? When you do this, things become a little separated out and easier to understand where the focus is. So then we go to the second step, that is the prior art search. The prior art search is all about finding solutions similar to your invention that already exists. And no, it is not constrained to your geography interest. Just because my invention is going to be sold in India, don't do a search only in India. Your prior art search is about across any part of the world, which means that even if you submit an patent application in the Indian Patent Office, when they want to check the novelty or the inventive step for that idea, they can pull out any patent or any content that is prior art from across the world and say that it's already known to anywhere in the world. people. Therefore, it is no longer patentable. So don't restrain your or constrain your search to only your geography of interest. Make it open-ended. So the 3 steps that I would say is search, compare, differentiate, strengthen one idea. The search part, I usually search by 2 aspects, and it's not like a fixed thing that I will search one or the other. I try both and see which gives me the best results. So you can of course search by solution itself. So from my problem solution system, I talked about a coating or a lubrication or a material composition that kind of reduces wear on blades, lawnmower blades. So you can talk about coating solutions, wear resistant or like impact resistant coatings. So you can search by the solution itself, or you can search by aspects of the components or the methodology. So you can talk about blade resistance. You can talk about, you can do a search on lawnmower blades. You can do a search on coatings. So breaking down into the various components of methodology also allows you to, it could also be a process of applying a coating to a lawnmower blade. So that could also be a potential patent. So when you do it by any one of these 2 approaches, either through solution or by components or the methodology, your chances of getting prior art or relevant prior art closer to your solution is much higher. And you go through the results and then identify the ones that are absolutely close to your own idea and invention. So if I look at the state of prior art search, how do I do it? It's very simple. For all inventors, this is an approach that I say, find relevant keywords or synonyms to get the accurate search string. You can use, I use things like Thesaurus, I use Wikipedia, Google, and synonym.com. So I know there is a lawnmower. Other ways in which people would call a lawnmower when they write a patent application. So I talk about blades. Other ways that I would use the word instead of blade, I might say cutting component or a cutter. So there are different ways in which people would call it. So if I use just one word, chances are I might miss out a few other relevant patents. So ability to make sure that you have all the relevant keywords to put in a search string to get the maximum number of relevant prior art is very, very crucial. And they should both be semantic and technical equivalents. What I mean out here is semantic is synonym, just the equivalent of the word. Technical equivalent is something that does the same job, but it's called by another name. So both of these you should consider when you build your search string. Then of course you choose the right patent databases. You can go paid or free databases. Paid databases like Derwent and Questel, they are very powerful and they're very good and they've been for a long time and they give very good results. The free databases like eSpaceNet and Google Patents also are very well updated and can be very easily utilized by most inventors to get good prior art and relevant prior art. Then of course you use also parameterized search operators, like you use proximity operators like say near 5, near 10 and so on and so forth. You can use Boolean operators like and, not, and nor also. As you use, depending on the database that you're using, the language might slightly change. But as you use these, you'll find out that this helps you not only to get the most relevant prior art, it also helps you to remove some of the noise or the junk or the irrelevant patents that keep popping up into my search string because it's very broad. The last step, that is analyze and differentiate. Not all results that you get in your prior art search could be relevant. So you still have to shortlist the only relevant prior art to your solution. So the way I use it is I use title, abstract, background, and summary. The way I look at it is, if you look at any patent application, the background and summary are very key areas that I use to my benefit. Title and abstract is very obvious from the words itself. Title gives the title of the invention. Abstract gives a very brief description of what they're trying to do. Background and summary are a little different. Background essentially talks about the industry that solution belongs to, that patent solution belongs to. What is the problem that they are trying to solve? So background gives you all this background history of what is it they're trying to solve. So it gives you a very quick map. They are trying to solve a particular problem. Am I even trying to solve the same problem? If it's not even the same problem, why do I care? It's not relevant. Summary tells them how they have solved that problem. So it's a precise technical summary of how their solution solves that problem. So both background and summary essentially encapsulates the problem solution statement that you develop. So these can be the technical differentiation. Is there some